5 seconds to go. Start. The factors that have persuaded the learned single judge of the High Court to allow the application filed by the accused, Waseem, are encapsulated in the following para. Considering the overall facts and circumstances, the nature of allegation, the gravity of offence, the severity of the punishment, the evidence appearing against the accused, submission of learned counsel for the parties, considering the law laid down in the case of Lakshmi Singh and others versus State of Bihar and others, Babu Ram and others versus State of Punjab, and Amarjit Singh versus State of Haryana, this court thinks that 11 accused persons are said to have assaulted the complainant's side after indiscriminate firing, in which only 3 persons had sustained injuries on their persons, who later on died in the hospital from the side of the complainant, and the accused side had also received serious injuries. Accused Niaz Ahmed has also suffered gunshot injury in the incident, and the injuries sustained by the accused side has not been explained by the prosecution. They ought to have been explained by the prosecution, and since it seems that there is a cross version of the incident, and it is very difficult to ascertain at this stage who was the aggressor, and it will be decided at the stage of trial after taking evidence from both the sides, but without expressing any opinion or merits, this court finds it to be a fit case for bail. Appearing for the appellant complainant, learned counsel submitted that this is a case of double murder of 2 young sons of the appellant complainant at the hands of the accused persons who harbored previous enmity against him and his family members. Waseem A7 was arrested on 27th May 2020. The other accused persons were arrested on different dates. After their arrest, the police conducted a search of the respondents and recovered 5 illegal country-made pistols, 7 live cartridges, and 5 used cartridges from the possession of Aslam A2. A specific role has been attributed to each of the 4 respondents herein that resulted in the death of the appellant's 2 sons and serious injuries to his nephew. All the 4 respondents herein were named in the FIR besides the other co-accused. During the course of investigation, the statements of 11 independent witnesses were recorded under Section 161 CRPC, wherein an active role has been attributed to all the 4 respondents. Later on, the appellant complainant entered the witness box and appeared as PW1. He has reiterated the role played by the respondents herein in committing the offence. 2 other independent eyewitnesses, PW2, PW3, and PW4, have supported the testimony of the appellant PW1. Learned counsel for the appellant complainant further states that the High Court has completely overlooked the fact that the respondents' accused parties were the aggressors who had forcibly entered the house of the appellant complainant and indiscriminately fired at him, his sons, and other persons who had gathered at his house to break the fast. They have criminal antecedents and several cases are registered against them. Even before completion of a period of 6 months granted by the High Court by an earlier order dated 7th April 2022, passed on an application moved by the appellant complainant under Section 482 CRPC for issuing directions to the trial court to complete the trial in a definite period, the High Court has proceeded to grant bail in favor of Waseem on the grounds of parity with his father. Similar orders have been passed in favor of Aslam. Stop.